Ladies and gentlemen, dear colleagues, friends, students, it is my pleasure to be here with you today and to bring your attention on maybe not so national issue, but we will see till the conclusion of this presentation. Maybe we will agree that there is, of course, quite important issue of the taxation regarding the tax dispute resolution mechanisms. They are, as we all know, mostly national, and this field is, let me say, not so visibly in the arena of the harmonization in the European Union. But we all know that in the last decades, maybe two, we are facing a sort of the global war against tax evasion, tax avoidance, and that is something that brings our attention as scholars to the dispute resolution mechanisms, and especially in this field of taxation. So as you will see, I have started with the title, that is a question, and maybe I will also conclude with some questions. In this presentation, I will try to cover just some basic things on the tax dispute settlement mechanisms. And of course, I think that at the European level especially, there is big efforts are doing in searching for such an more effective mechanism. We have done a few years ago at the level of the Association of European Tax Law Professors and research, and it was covering pure or national situations, but also and European. And it is obvious that the resolution of tax disputes in the EU and broader globally, when we are looking, that there are so many differences. But in the same time, this national situation, those national situations are showing that there is a similar or the same need for more effective resolution of tax disputes. Mostly we are dealing with the European or cross-border tax disputes, and we are not satisfied, and that is the arena where we are developing European legislation. And I think we are aware that this European legislation is strongly influencing national situations. So I'm not sure if we will agree, but there are some signs of that we are already have somehow introduced some elements of the European law in tax procedures that are mostly national. And I think that is also the case with the tax disputes mechanism. We all know that this, as I mentioned, global war against the tax evasion and tax avoidance is not just in the base erosion and profit shifting plan that is well known, but there are legislation consequences at the EU level. And the growing number of tax disputes is something that is present in a national frameworks and also at the European level. So this growing number shows and confirms that there is a necessity of taxes for defining such a mechanism. In the same time, we also can see that a soft approach does not bring wanted or results. So we should think more how to deal with this need. One of the procedural parts of this search for more effective mechanism shows that we need to involve taxpayers more effectively, and there is such a necessity to include taxpayers more. This means that taxpayers have, of course, taxpayers' rights, and this is something that we should also, in this context, mention. very famous, or not famous, but we have in a tax arena community quite familiar with tax arbitration. Tax arbitration is one of the possible mechanisms to try to solve the tax disputes, but it is not so successful. And I have, as I said, some dilemmas or questions instead of the conclusion. In this first part, as I mentioned in this introduction, I said we are living in the time that we have not just BEPS, but have quite a big fight against the tax evasion, and this is about the story about the international tax avoidance, and states or member states, but more wider at the global level, we have quite strong international tax cooperation and coordination. So that is something that is very, very important. And of course, such an cooperation and coordination and fight against tax evasion brings us to the more complex and more complexity in this international at the level of the international taxation, meaning of course and European, and meaning of course and at the national level too. So it all brings us to that situation that I didn't bring you here the numbers, but the numbers shows that at the national and European and global level, international disputes we are facing with a seriously growing number of disputes in taxation, and that was the reason that I put some dilemmas. Should we work more intensively on the prevention of disputes? And this is the field where European legislation shows that we have positive results, and I think that we should further insist on the preventing disputes, but it is not enough. So we should go further and search for such an more effective mechanism. In international taxation, we are usually talking about mutual agreement procedure that should be one of the mechanisms to resolve tax disputes, but as I put here, it is maybe a question, can we rely on mutual agreement procedures? The results shows that it will not be enough. And as third dilemma or question for all of us is, should we look or search for such a more effective mechanism in the field of non-tax field? So it is also something that we should discuss, if we can find such a mechanism in other fields. So that are some dilemmas and questions. We have, as a result, as I said, as a result of BEPS, but not only that, beyond this implementation at the EU level directive that is on the EU tax dispute settlement, and it means that we have EU secondary law on the tax disputes. Of course, it means European courts jurisdiction. It brings us to quite important field of the protection of the taxpayers' rights. That is the field that I really love, and I usually try to go in discussion in that direction, but this is not the moment. But the fundamental, or not just fundamental, rights of the taxpayers as affected persons are now in a first when we talk about the tax dispute settlement, then we are talking about the protection of rights of the taxpayers. So in that sense, still I'm going one step back and try to see how to prevent tax disputes. And one of the possible instruments, of course, it is also well known in some member states, is use of the mediation. But in general, there is very, very strong influence of the not just as we have the secondary law, but there is strong influence on the national tax procedural laws and on the national tax disputes laws. So that is sort of the Europeanization of the mostly national field of the taxation. One of the problems and something that we should work on is the issue how to make more efficient mutual agreement procedures that are going to be used as the instrument to resolve some of the international tax disputes. And we are faced, in this field, we are faced with very important issues of the discretionary powers, of course, of the states that are in this procedure involved. So we have some questions if those discretionary powers are in a line, or are they comply with the rule of law principle, and something that we should discuss. And I think it is very, very important to mention in this context. Some of the well-known rights, not only of the taxpayers, but in this field, yes, it is important to mention. What is with the right of being heard? What is with the right of defense when we talk about mutual agreement procedure, and the position and the fundamental rights of the taxpayers? So in this sense, that is something that we are facing while we are searching for more effective instrument or mechanism for tax dispute settlements. Not famous, but in practice we are all know that there is big importance of the tax arbitration, but in the same time this trend of using mutual agreement procedure and multilateral instrument arbitrations, there are some shortcomings of these basic two types of tax arbitration, and we are sure that this increase in the number of this international tax arbitration shows that this means, of course, there is a significant increase of money or amount of tax revenue that is affected. So it means in the same time that international tax arbitrations will not be anymore something that is not in a political radar, and of course that's something that is not of interest of not just taxpayers but in general citizens. So as I said, instead of the conclusion, I offer you still not questions and dilemmas, because there are limits of the existing dispute settlement mechanisms in the field of the taxation. There are possible ways and proposals, but they assume that we are going in the area that means a sort of the loss of the sovereignty, and we all know that that is something that is very sensitive. And as I said, we should use good experience in legislation, in legislative success of the European Union, and of course at the national level of preventing tax disputes. And we should go further and trying to find the mandatory mechanism for tax dispute settlement at the EU level as international disputes mechanism settlement, but of course it will bring at the national level also many dilemmas. We cannot rely, I think we cannot rely on the mechanism that we have now, including mutual agreement procedures, and additionally it means that we should search for settling tax disputes through the non-tax dispute settlement instruments. So that will brings us, of course, to some other new mechanisms and some other questions. But of course, it shows that this pure national field of the tax procedure and tax dispute settlement is also under the pressure of the legislative, not just the legislative European actions, but more, I think it is also the global issue. So if you have any question, I'm here and will be happy to discuss on this. Thank you very much.